Good morning, dear friends and colleagues. If you're seeing this live, you know that today is the 14th of June, 2024. It's 10 o'clock in the morning, and we have a very interesting educational topic today and content-related topic obviously as well. I'm very happy to introduce Mariana Rissetto, and Marco Blocher to you. I constantly mix the name. I'm sorry, Mariana. After 4 years, I still can't really pronounce your name properly. I'm sorry. But I try my best. I'm improving, hopefully. So Mariana Rissetto is a research associate at the Department of Innovation and Digitalization in Law at the University of Vienna for quite some time already. We have been working together for many years now, quite intensely and successfully. And Mariana was also already here in this podcast when reporting about the COVID-related situation in her home country, which is Argentina. Marco Blocher, whom I have been working with in several circumstances, including the Data Protection Moot Court, also for quite some time now already, is a lawyer by training, and he has been working at the NGO NOYB, or None of Your Business, which is the NGO founded by, in particular, Mark Schrems, situated and placed here in Vienna, dealing with privacy and data protection issues in the information society. And the topic of today's talk is, in my view, very interesting and innovative teaching format that was invented by Marco and others. We will come back to that in a second. And that deals with GDPR and data protection in the format of a so-called moot court, and what this is and why this is of interest in particular, but not only for law students. This is the topic of this conversation today. Very happy to have you both here, Mariana and Marco. And Marco, first question, you were one of those inventing this. So how did that go? Why did you invent it? What is it about? And why are you still there?
Yes, so back when I was a student at the University of Graz, I participated in a civil law moot court, and I liked the experience very much to not only study law theoretically, but to sort of apply it in a fictional practice, that is. And after I started a career in data protection law, I at one point was just wondering if there is such thing as a data protection moot court. It turned out there wasn't. So I sort of spun the idea with colleagues back then, and then together with a colleague and another friend who's working in data protection law, we started the Data Protection Moot Court. Back then it was called GDPR Moot Court, and it focused solely on Austria because we're here based in Vienna, and it was still in German. We did that back then together with Elsa Austria, who supported us, and it went quite well. But after this very first edition, or edition 0, so to speak, we decided to go international, which makes a lot more sense for a GDPR or a data protection moot court, which is dealing with European law and not national law only. And because Elsa Austria couldn't support us there any longer, fortunately, the University of Vienna department, and in particular Mariana and her colleagues, chipped in and started to help us now setting up what we have now as the DPMC, the Data Protection Moot Court, which is not only for Austria and in German, but is open internationally and is taking place in English.
Mm-hmm. Mariana, so what is your contribution to this? How did you enter this? Why did you enter this? And why are you still here?
Yeah, thank you first of all, thank you for the invitation and having the possibility to talk about the Data Protection Moot Court in this forum, in this discussion. I entered myself in 2022. I just heard there's a data protection or a moot court on data protection, and I'm really into the subject, specifically subject matter wise, and also sharing some of the experiences that Marco shared. I was also as part of my studies, part of a moot court competition, and for me it was actually the first time that I come closer to the practice of law. Before that, it was mainly theoretical. And I loved the idea, I loved the initiative, I loved something that is also starting, so the startup and all of these new challenges that pose, and especially the connection and the benefits that this type of moot courts or scenarios brings to students. And we hope actually to try to reflect as well that to current students that are perhaps in the same or similar situation. That's why we accept students and only recent graduates, where they do have the possibility to have perhaps the first of all practice or practice-alike experience in law, and also an interest and a high interest in data protection.
Mm-hmm. Marco, you said that you decided to go international. So what does that mean in practical terms for students now? Who is supposed to apply, and how could people apply?
In general, the applications are open worldwide. If you look at the topic, it's European data protection law. Of course, I think students from European universities would have it a lot easier because they're already studying this ideally, but we're not excluding anyone from outside the European economic area. And it is in English, so students that want to participate should, of course, have a good command of English. They should be familiar to a certain extent with the European data protection law. That does, however, not mean that they have to have some expert level on this. This is supposed to be a learning experience, and it is open for everyone who is willing to give their best and who brings the right set of skills to this.
Mm-hmm. But do they need to travel? Are they expected to invest money into this?
No, they're not, and that is, I think, a benefit of the Data Protection Moot Court. Initially, this was not because we thought it was great to have it fully online, but it was because we started the very first edition in COVID times, and it was just not possible to have it on site. So the Moot Court started to be fully online. It takes place on video platforms, such like the one we're here today. And we kept that. We kept it fully online, not only to keep the threshold of participation low, but also I think it reflects sort of the topic of the moot court, because it is a data protection moot court, and it sort of fits that it's taken place online, I think. So we decided to keep that, and this also allows us to keep it free for students. So there is no admission fee or anything.
Okay, so that's already an important message, which is if you are a student and you have an issue in paying for the admission fee or for the traveling coming with other moot courts, this one here is an option that is available for free. Mariana, when you look into this from a teacher's perspective, what are the specific challenges coming with this format in your view?
Let's say the only, disadvantage or challenges I would say is we don't know, as of course we are not teaching that subject matter. We don't know what let's say the level of knowledge on a specific European data protection law from students is. Therefore, we have this as a kind of mitigation and perhaps improvement measure, where, of course, the subject is actually not that of a specialization of students. The possibility to bring coach, actually, this is mandatory. So each team should bring a coach with a certain specialization or years of experience in the field. I know that, of course.
Could you just make that a little bit clearer? So this means that if I apply as a student, do I need to bring a coach, or is the coach assigned to me? Or yeah.
Sorry, we do have two sorts of applications. So we are accepting individual applications in order then to form teams and composed of 3 team members, or we are accepting teams applications where they could have, let's say, the possibility to bring a coach already to the team.
Okay, which means that if I'm a student somewhere in Europe and I'm interested in data protection law, I can either do this as an individual, or I can try to find 2 friends and someone having more of an idea about data protection than me, who is willing to work as a coach. Is that correct?
That's correct. Yeah.
Okay. And both.
For the team, sorry.
Go ahead, Mariana.
To add on this, for the teams that are formed by the DPMC organization, so basically based on the individual, like successful individual applications, we appoint the coaches for those teams.
Okay, which means that in any case, even if I didn't know anyone working in data protection law, I could apply. And the positive outcome of this would be that I might meet team members from somewhere else in Europe with whom I then need to work remotely, hopefully learning something about data protection, but also about different legal cultures, educational cultures, etc. Correct?
Exactly. Yeah. And perhaps on that, because your question was also the challenges, right? And this could actually be a challenge, but also a huge advantage. So the challenge of having this online is basically you might not meet your team, like your colleague, in the whole course of the moot court. But today, and this is actually the teaching positive experience, and learning experience, we are working with an international colleagues online, which actually this reflects pretty much, perhaps if not 100% of the working environment, where there are interdisciplinary international teams working without just fully remote. And this is actually the added value as well of having this online, also of applying individual, so not only for knowing how to work and produce an output with the same aim, with people from different backgrounds, different genders, different geographical locations, and perhaps even different interesting in other parts, which is not only data protection.
Okay. So, Marco, coming back perhaps to your personal history of this, when you started with this, normally a moot court means that students work on a case, and the case needs to come from somewhere. Where is the case coming from?
Yeah, so the case comes from us. We're writing that. It's a purely fictional case, so that means we're not saying there is some existing social media company processes this and that data, and the complainant team is supposed to form a complaint on that, but it's purely fictional. However, it is always based on, let's say, current societal events, current trends in data processing, and so on. And I mean, and of course, I'm not telling what precise case we're going to have this year, but in our day and age of information society, like every situation of the everyday life can be assessed from a data protection viewpoint. There's no way around it. And so there's many possibilities how the case can actually be and what students will be dealing with. And I think it's very interesting for aspiring lawyers because, as I said, there's no way around data protection nowadays. And of course, for them, it compared to other fields of law, I think data protection also allows for somewhat more leeway in arguing your cases still, because it's still a relatively young field of law. If you compare it with civil law that has thousands of years of traditions where lots of problems have been dealt with in one way or another, it's not always the case in data protection law. So the case can be in many directions, and and it's always in the manner that it allows two viewpoints. So none of the teams, either the controller teams or the data subject teams, is favored by the case, so to speak.
And you are writing the case, correct? Or at least
I'm writing the case. Yeah. So this is my contribution to the moot court.
Let me just emphasize that I find this really astonishing and very impressive, the way you are writing this, because I read obviously all the cases so far, and they are excellently written, and the problems behind them are really, really interesting. And you also manage, in my view, at least you manage it very well to distribute the tasks equally among the two competing or challenged partners in each of those situations, because this is, in my view, probably one of the really complicated things here, that you distribute the difficulty among the two competing partners equally, and this is excellently done. How do you do this, by the way? Is it just you, or how are you doing this?
I don't know. It's just, I mean, I like writing in general. I also creative writing, so maybe I have a knack for it. But yeah, I'm glad you like it. We also publish the cases after the moot court is over, so they're free to use for anyone.
Yeah, Mariana.
Perhaps just I wanted to add, I think that also the advantage of the case, we have two variants of the case. So even if we have one case, we have two variants. One that is circulated to the data subjects first, that has certain, let's say, information, and the one we distribute then the variant to the data controller teams, which is slightly different, with some information either missing or more information compared to the first variant of the case. And we also the advantage of this is actually we wanted to reflect as well the practicality. So basically, not the data subject or the data controller would always receive the same information. So basically, we want to also reflect reality. The most,
this is one of the things that I really like about this, and I don't think that it's very common in many moot courts, that the information that the different groups receive is not the same. So just like in life, right, you're expecting the others to know something, and then it turns out that they know something different, or they know more or less than you expect them to know. So that is very realistic, in particular when it comes to data related issues here. I really like that. Mariana, let me ask you one study related or students related question, which is obviously students need to, if they decide to do this, they need to invest quite some time into this. What is the outcome for most of the students, apart from hopefully some learning experience in data protection? So do we have any experience on whether this is accepted as a relevant part of their studies and so on? Is there anything you want to share on this with the audience?
Yes, we do have some experiences, or at least what we heard from the feedbacks, and perhaps we still remain in contact with one of the former participants of the moot court. It's basically that after participating during the moot court, they even were offered a job position or an internship position in specialized data protection law firms. And this is, I think, very relevant. And this is also not only reflects in terms of job-wise, but also the number. We have metrics in terms of the number of participants, or at least applications every year, which are, of course, we read this as an interest and possible, let's say, employment, let's say, possibilities, which of course this is an extra value not only from the learning experience.
Yes, and do you have any guidance or any recommendations to make when it comes to whether this is accepted as part of their studies, so that their university is accepting this?
Unfortunately, I know regarding ECTS or recognition, we don't have. Unfortunately, for now, we don't have it. We are planning to do so. Whether just to apply, so let's say the time that you invest here, at least at European universities. We did have, and the university, the department offered in 2022 a course. It was a course for preparing to this moot court, and we didn't offer that last year, but I think this was also like part of the recognition for students, formally speaking.
If I may add, I think it's still important to encourage students to ask back with their university whether or not the moot court could be could lead to ECTS being granted. It's possible. It depends very much on their university. So we can't say that in general, but for some it was possible to get ECTS for this.
Yes. True, and they need to do this on their own. But if they are coming with a coach, and the coach is coming from their university, that might increase the possibilities coming. Okay.
Yeah.
Perhaps one thing about the actual planning where we are at the moment. So we are doing this recording in June 2024. What is the status of the DPMC for next year at the moment? Where do we stand?
For next year, this year, sorry.
This year, I mean
this year. Okay, yeah. So basically, we are already in the applications phase. The application starting 1st of June. We are ending the applications on the 15th of September. So there's a lot of time to apply. The application requirements are in the rulebook, but anyway, there's an online form available through our website where we request a motivation letter and certain personal data. Of course.
First thing, if I may interrupt, is that people need to go on this website that I'm just inserting here at the moment, right? And they will find the necessary information there to apply until 1st of September, you said?
15th of September.
15th of September. Okay, this is what they need to do. Okay, what's going to happen then?
Then we have, of course, let's say the selection phase. Internally, students or teams are selected, and we have a first introductory meeting, just a kickoff of the formal kickoff of the DPMC. This is on the 7th of October. From there, on the same day, the service, we provide the service of the case for the data subject teams, and they will have let's say until, I think I'm having here the timetable, till the 28th of October to submit the written complaints, which 2 days later we provide the service of the case to the data controller teams. And they had until 20th of November. So basically it's almost a month, to perform the written complaints.
And
sorry, the last point,
sorry, Mariana, just to interrupt here. As a student, may I ask whether I'm part of the complainant or the data controller team, or is this assigned by the organization?
This is assigned for various purposes by us.
Okay, so it's assigned. So no choice here to make, right? So no choice, which also means that there is some unclarity about when I'm expected to write as a student, correct? Because if I'm writing as a complainant, I need to write earlier than as a data controller.
Exactly, yeah.
Exactly.
But you are, I mean, the teams, of course, are aware of whether they are data subjects or controllers.
But if I'm applying, this means that I should be better prepared, that I need some time either in early or later in this phase, meaning early October or late October, correct?
The precise timetable is online in the rulebook, so people should block both. For both cases,
should block both dates. This is what I'm asking. Okay, so Mariana, please. Sorry, I didn't want to interrupt.
No, but it's a very valid question. We do have some reasons why we assign the data subject and controller teams to the teams. And so basically this is entering the written phase of the moot court. Then there is the oral phase where the teams plead their case before a jury of three members, and we do have since last year a final oral hearing for where the best data subject team and best data controller team playing against each other in a final event that luckily or hopefully is again live streamed via Ars Boni. That was the case last year.
Yes, so for my side, yes, for sure. Okay, and no,
go ahead. Sorry.
No, go. Okay, so my question would have been then perhaps to both of you. You rightly mentioned now that there are juries assessing the performance of the students and the teams. Who is in the jury, and what is the role of the coach during the oral hearings?
Yep, if I may. So the jury consists of 3 people. One of them is always one of us, so one of the organizers of the moot court, and the other 2 are external jury members, and that's lawyers that have some standing in data protection law. They could come from within companies. They could come from law firms working in data protection law. They could come from universities. Mr. Fogo, you're also helping us as a jury member. And this jury, during the oral hearing, then asks questions to the participants, and they also grade their performance in the oral hearing. That's the task of the jury. The performance in the written submissions is only graded by us, by the organizers. So the external jury members don't grade the written submissions.
And what do the coaches do or not do?
And the coaches are supposed to prepare the teams for, so they assist them with their written submissions without actually writing them. So since this is an educational tool, it's okay for the coaches to let the students make mistakes. It's fine that the submissions don't have to be perfect. The coaches should guide them without actually writing them or helping them too much. It's a bit of a narrow path here. In the in the oral hearing, the coaches just listen. They're not supposed to intervene. They're not supposed to help their students prepare when they're in a breakout room to prepare their reply to what the others said. So they just listen in.
Okay. Mariana, please.
That I wanted to add regarding the jury member composition and how we decide the composition. We try to have always, or not always, but we try to have representatives of authorities. And here we had for already many years, the Austrian Data Protection Authority as very much involved as part of the jury members. We have also practitioners and also academia. And I think that this, let's say, triage of different stakeholders is also a very important, let's say, keynote for students also to know not against, but before who are they pleading.
Okay, so Marco, you are sitting in front of a logo of none of your business, which means that there are partners in this game. I assume there is a reason why you're sitting there with this logo in the background. There are partners in this game which are not students that are equally important, and that's probably as we mentioned already, the coaches. So typically the coach is someone who has some experience in data protection, but there are also sponsors and external partners. So perhaps both of you could explain a little bit about their roles and what they're doing.
Yeah, so I'm here for NOIB, so to speak. I'm a data protection lawyer at NOIB, and NOIB is supporting this moot court, and that is mostly through my contribution as writing the case. I will also sit in the jury, not in all of them, but because the jury composition for each competing teams is different. And some of my colleagues might also help as coaches. That depends, of course, on how many applications we get where people already have their coaches. But if there's need to be some of my team members might also participate as coaches. Max Schrems, the founder of NOIB, might also be in one of the juries. We, of course, make sure that there is no conflict of interest. If that there should be the impression. So I would not sit in a jury where the team has been coached by NOIB members, for example. That can be avoided easily because we have, I think, almost 14 teams participating.
Yeah.
And yeah, I mean, just to add to that, we had supporters and sponsors as supporters, basically NOIB and the department, but we do have sponsors who contributed, let's say, supported having in-kind contributions, supporters having financial contributions to the DPMC, especially on the administration and organization, which we are very thankful for. We do have at the moment 3 sponsors who have also been quite active last years as well, and to be the University of Vienna. Sorry, just as a alphabetical order. Fisher is a law firm at the University of Vienna, and TWP, which is another law firm from Austria. And without the sponsors and the supporters, we will not be here, since, of course, we are doing this, let's say, on a modus proprio, pro bono, on our free time, and this allows us to set up a professional environment for a good learning experience.
Okay. Wonderful. Perhaps another thing we could possibly do is that we simply go through the website very briefly. So if someone wishes to apply now, this is the website and this is the way to follow. If you want to sponsor, this is where you would end up as a sponsor most likely. There's an open call for sponsors and partners available at the moment, and there's plenty of information about the Data Protection Moot Court available on the website. Is there anything any of you wants to highlight on the information people would necessarily need to read? I would assume it's the rule book, right? That is probably the most important part. Could one of you kindly explain what this is and why this is important?
The rule book is, so to say, the constitution of the moot court. So this is, it's all written down how it works, what the rules are, the rules that people have to comply with, how their submissions are being graded, when everything takes place, what is to be expected in the oral hearings, the exact steps, and also for the unlikely event that has never occurred, how we deal with violations of the rule book. So I suggest that applicants just familiarize themselves with it so they get an idea of how this all goes down.
Yeah, so it's somehow the law of this.
Yes, our constitution.
Yeah. Okay. So if you are deeply interested in this, read the rule book. If you are not that interested but just want to join quickly, the fastest way to do that is to please look into the timeline, keep all deadlines, and simply click on apply here, and then apply either as a team or as an individual. A personal question perhaps to both of you. What have you learned out of your teaching and organization experience from this moot court so far? What is the most important personal learning for both of you?
And personally, I was very surprised of, let's say, how the Brussels effect really takes place in data protection law. GDPR is always branded as the flagship law in data protection, and I suppose it is also true on an educational level, because a lot of applications we received are from outside the European Economic Area. So even students that don't live in areas where European law applies study it, maybe because their states are coming up with legislation that sort of follows the GDPR. And there was also quite impressive expertise by these in data protection matters by these non-European students. So that really surprised me that this Brussels effect also applies here.
Yeah, we should perhaps also mention that at least as far as I remember, at least in two of them, non-EU university teams won, right? This is astonishing.
Yeah.
Mm-hmm.
Yeah.
Yeah, so that's quite impressive here.
Yeah. Mariana.
Yeah, for me, it's the knowledge, the level of knowledge of participants, which I was very surprised, and the eloquency of most of the teams while pleading the oral hearings, which of course at the stage of being a law student, you might not take that for granted. So the well preparation, the investment, and actually the love for for data protection. As we said, this is just an add-on in their studies. Of course, it has, let's say, concrete advantages for participating. But this was, for me, one of the most astonishing things. And personally, I learned a lot about project management. Kind of considering fast project management by learning.
Okay. This is what all of us are doing all the time, right? So
exactly.
Yeah. Okay. So is there anything else you want to share with me and the audience on this upcoming event and the upcoming challenges coming now and opportunities coming now? Should we mention something that is specifically important that we haven't mentioned yet?
Perhaps one last word on we're very, very looking forward for applications from all over. So please apply, please be interested also as a coach. And if you're also interested about the initiative, we have a lot of, let's say, possibilities and ideas to grow and do this even more professional, even more interesting, even more appealing for law students. So of course we also welcome any kind of support or sponsorship at the end.
And for
perhaps thank you for everyone. Yeah.
And for the students that apply and are not successful, two things. First, this doesn't necessarily mean that they were that they didn't meet the criteria. We have plenty of applications, and sometimes we were forced to exclude teams or participants that were really good. So don't be disencouraged by that, and please do apply for next year's edition, because this is going to happen. So we plan this to be an ongoing thing that happens every year. So if you apply and are not successful this year, please do reapply next year.
Wonderful. Okay, but I assume that many of those who are listening to this will be successful, and I want to congratulate everyone who applies to this, because I think I think it's a very, very interesting learning experience in one of the most important and most challenging areas of the law that one can find. So really, really a good choice if you are deciding to join us here. Would be very, very pleased to see many of you in this event again, or for the very first time. Just let me repeat once again, this is the website. This is the address that you need to follow if you want to be part of this experience. And we are very, very much looking forward to hearing from you. Thank you for listening to us. Thank you, Marco. Thank you, Mariana, for joining us here. Very much appreciated. I do hope that we stay connected, that you stay interested, and most